The idea that judges operate without external influence is a cornerstone of democracy, but reality paints a different picture. In the U.S., many judges receive indirect funding from billionaires and corporations through opaque channels. While the Constitution mandates impartiality, financial dependencies create conflicts of interest. Studies show that judges who benefit from corporate donations often rule in favor of big business, undermining public trust in the legal system. Wealthy elites avoid direct bribes by funneling money through foundations, think tanks, and political action committees. These entities then sponsor judicial conferences, luxury trips, or even academic positions for judges. For example, conservative billionaires like the Koch brothers have funded seminars where judges learn free market principles, which later reflect in pro-corporate rulings. Such indirect payments bypass transparency laws while ensuring favorable outcomes. Many states elect judges, making them vulnerable to dark money, undisclosed political spending. Billionaires exploit this by funding attack ads or supportive campaigns for preferred candidates. In states like Wisconsin, corporate-backed groups spent millions to install business-friendly judges. Once elected, these judges frequently side with their financiers in cases involving labor rights, environmental regulations, or consumer protections. Corporate-linked nonprofits often sponsor judicial education programs, effectively buying influence. For instance, the Federalist Society, funded by conservative donors, has shaped the ideology of numerous Supreme Court justices. Judges attending these programs receive ideological training that aligns with corporate interests, raising questions about their neutrality in cases involving their sponsors. Several Supreme Court justices have close ties to wealthy benefactors. Clarence Thomas, for example, accepted lavish vacations from a Republican megadonor but failed to disclose them. Similarly, Neil Gorsuch sold a property to a law firm executive with business before the court. These relationships cast doubt on the court's impartiality in high-stakes corporate cases. Landmark cases like Citizens United and Janus v. Afsam disproportionately benefited corporations and billionaires. Critics argue these decisions were influenced by judges with ideological or financial links to conservative donors. The outcomes weakened unions, expanded corporate political spending, and entrenched wealth inequality, proof that justice is not blind to money. Lobbying groups don't just target legislators. They also influence judges through amicus briefs and behind-the-scenes networking. Corporations hire former judges as lobbyists, leveraging their connections to sway rulings. This revolving door between the bench and corporate lobbying firms erodes judicial integrity. Many judges fail to report gifts, travel, or speaking fees from partisan groups. While federal judges must disclose certain income, loopholes allow them to hide benefits. For example, some judges receive book deals or paid memberships in exclusive clubs, creating unspoken obligations to wealthy patrons. Current ethics laws for judges are riddled with gaps. Unlike politicians, judges aren't strictly prohibited from accepting gifts or payments from interested parties. Some states don't require recusal even when a judge has clear conflicts of interest, enabling billionaires to shop for favorable judges. In McCutcheon v. FEC, the Supreme Court struck down campaign finance limits, a decision celebrated by wealthy donors who funded certain justices' careers. Similarly, lower court judges have dismissed lawsuits against corporations after receiving indirect support from them, proving that justice has a price. Mainstream media often overlooks judicial conflicts of interest, focusing instead on political scandals. Corporate-owned news outlets avoid scrutinizing judges linked to their parent companies or advertisers. Investigative reports on dark money in courts are rare, leaving the public unaware of systemic bias. When exposed, these stories are buried or framed as partisan issues rather than threats to democracy. Without scrutiny, corrupt practices thrive unchecked. Polls show declining faith in the judiciary, with many Americans believing courts serve the wealthy. High-profile cases where billionaires win improbably favorable rulings fuel this distrust. When judges refuse to recuse themselves despite clear conflicts, it reinforces perceptions of a rigged system. Eroding confidence undermines the rule of law, incentivizing more exploitation by elites who face no consequences. In nations like Germany or Canada, strict ethics laws limit judicial ties to private interests. U.S. judges, however, operate under weaker rules, allowing billionaires to exploit loopholes. Some countries ban judges from accepting gifts or post-retirement corporate jobs. The U.S. system's permissiveness contrasts sharply, revealing how legalized corruption became normalized in America's courts. Reform advocates demand mandatory disclosure of all judicial funding and recusals for conflicts. Bills like the Judicial Ethics and Anti-Corruption Act propose banning gifts and dark money, but face opposition from powerful lobbies. Without transparency, judges can secretly cater to donors. Public pressure is needed to force accountability, but entrenched interests resist change. Super PACs spend millions to influence judicial appointments, backing candidates who align with corporate agendas. Federalist Society-backed judges, for example, dominate federal courts after massive spending by conservative donors. These judges often rule against regulations, favoring deregulation and corporate immunity. The appointment process has become a proxy war for billionaire ideologues. Retired judges frequently cash in by joining boards of companies they once ruled on. Former Supreme Court Justice Sandra Day O'Connor served on corporate boards, while others become lobbyists. This revolving door incentivizes rulings that please future employers. Post-bench careers reveal how justice is treated as a stepping stone to private profit. Insiders who expose judicial misconduct risk retaliation, including disbarment or blacklisting. Unlike whistleblowers in other sectors, legal insiders lack protections. Judges and lawyers who speak out face professional ruin, while media often dismisses their claims. Fear silences potential reformers, allowing corruption to persist. Grassroots movements push for stricter ethics laws and term limits for judges. Some states experiment with public financing of judicial elections to reduce dark money. However, without federal action, patchwork reforms fail to curb systemic issues. The 2023 Supreme Court ethics scandal reignited debate, but legislative gridlock prevents progress. Voters can demand transparency laws and support judicial candidates refusing corporate money. Advocacy groups like Fix the Court track judicial misconduct, while boycotts pressure corrupt firms. Public awareness campaigns highlight conflicts of interest, pressuring judges to recuse. Change requires sustained pressure on lawmakers to prioritize justice over donor interests. Evidence proves that billionaires and corporations distort justice through funding, lobbying, and revolving door patronage. Until judges are financially independent, the law will favor elites. The illusion of impartial courts crumbles under scrutiny, revealing a system where money buys verdicts. Restoring trust demands sweeping reforms, or America's judiciary will remain a tool of the wealthy. Behind the scenes, billionaire-funded organizations like the Federalist Society and American Constitution Society shape judicial ideologies through curated seminars and networking events. Judges attending these events often adopt frameworks that align with corporate interests, which later reflect in their rulings. These networks operate like shadow education systems, indoctrinating judges while avoiding direct bribes. The lack of transparency makes it impossible to track the full extent of this influence. Some wealthy elites bypass traditional judicial appointments by funding their own political careers, eventually landing judgeships. Examples include businessmen-turned-judges who rule on cases involving their former industries. Their inherent biases toward corporate interests raise questions about fairness. When judges come from the billionaire class, their rulings often protect wealth rather than uphold justice for ordinary citizens. Through strategic donations to judicial election campaigns, corporations effectively veto judges who oppose their interests. In states with elected judiciaries, business lobbies spend millions to defeat judges who rule against them. This creates a chilling effect, where judges avoid challenging corporations to keep their careers intact. The result is a justice system that fears punishing powerful entities. Media often frames judges as either pro-business or anti-business, but this is a misleading simplification. Many so-called pro-business judges are simply pro-donor. Their rulings favor specific corporations that fund their careers. True impartiality would mean judging cases based on law, not economic ideology. Yet, the financial incentives make unbiased rulings increasingly rare. Numerous federal judges have dismissed class action suits against big pharma, tech giants, and polluters, often after receiving indirect support from these industries. By limiting consumers' ability to sue collectively, these rulings protect corporate profits while denying justice to victims. The trend suggests a systemic effort to shield corporations from accountability. Corporate-funded think tanks produce research that judges cite in rulings to justify pro-business decisions. These organizations, often backed by dark money, frame deregulation and corporate immunity as constitutional principles. Judges who rely on such biased sources effectively outsource their reasoning to billionaire-funded ideologues. Supreme Court justices and federal judges earn hefty sums from book deals and paid speeches, often to groups with business before the courts. These payments, while legal, function as indirect bribes. When a judge profits from entities they may later rule on, their impartiality is compromised, yet ethics rules fail to prevent these conflicts. Judges have expanded corporate rights under the guise of corporate personhood, granting businesses free speech, citizens united, and religious liberties, Hobby Lobby. These rulings, often decided by judges with corporate ties, blur the line between human and corporate rights, empowering businesses to override public interest laws. Many judges who received funding from anti-union billionaires have ruled to weaken labor protections, limit collective bargaining, and uphold non-compete clauses. These decisions disproportionately benefit corporate donors while suppressing wages and worker mobility. The correlation between judicial donations and anti-labor rulings is too consistent to ignore. Oil companies and polluters facing climate litigation often draw judges with histories of siding with industry. Some federal courts have dismissed climate cases on dubious procedural grounds, delaying accountability. When judges with fossil fuel investments oversee these cases, recusals are rare, proof that corporate influence extends to environmental justice. Judges impose lenient sentences on corporate criminals, e.g., bankers in the 2008 crisis, while harshly punishing low-level offenses. This disparity reflects implicit bias toward wealth and power. When a Wall executive gets probation for fraud while a petty thief gets years, the message is clear: justice scales tip for the rich. Patent rulings that extend drug monopolies, often written by judges with pharma connections, keep medication prices artificially high. These decisions prioritize corporate profits over public health, blocking generic competitors. The revolving door between judges and pharmaceutical lobbyists ensures this cycle continues. State bar associations rarely discipline judges for ethical violations, even with clear evidence. Many bar leaders have corporate ties themselves, creating a culture of impunity. Without accountability, corrupt judges face no consequences, further eroding trust in the legal profession. Some rulings effectively legitimize tax avoidance schemes, allowing billionaires to exploit offshore accounts and shell companies. Judges who benefit from donor networks rarely challenge these tactics, even when they violate the spirit of tax law. The result? A legal system that helps the rich hide wealth. In rare but alarming cases, judges overturn jury verdicts that punish corporations, substituting their own pro-business judgments. This undermines the democratic function of juries, suggesting elites don't trust ordinary citizens to decide fairness. That by enforcing mandatory arbitration clauses, judges strip consumers of the right to sue corporations in court. Many of these judges have ties to firms that profit from private arbitration, a clear conflict of interest. Studies show stock prices of certain companies rise after favorable judicial appointments, proof that markets anticipate pro-corporate rulings. When justice becomes predictable for Wall Street, it's no longer blind. Even after convictions, judges often give executives probation or cushy prison terms. Compare this to harsh sentences for minor crimes, another sign of a two-tiered justice system. Some argue AI could eliminate judicial bias, but who programs the algorithms? If corporations influence the data, even neutral, AI could perpetuate bias. The core issue, power imbalance, remains. Unless citizens demand transparency and accountability, courts will keep serving billionaires over justice. The choice is clear: reform or accept a justice system that's auctioned to the highest bidder. The intertwining of wealth and judiciary dates back to the Gilded Age, when industrial tycoons like Rockefeller and Carnegie influenced courts to crush unions and monopolize markets. Landmark cases like *Lochner v. New York *, 1905, which struck down labor laws, set precedents prioritizing corporate interests. This legacy persists, with modern billionaires replicating tactics to shape legal frameworks that protect their empires. Elite law schools, heavily funded by corporate donors, train future judges to prioritize free market ideologies. For example, Koch-funded programs at George Mason University promote deregulation theories. Graduates appointed to benches often replicate donor agendas, embedding pro-corporate biases into rulings. This indoctrination creates a pipeline of judges sympathetic to billionaire interests. Supreme Court clerks, often selected from Ivy League schools with corporate ties, draft opinions that sway landmark decisions. Many clerks later join corporate law firms, creating a feedback loop. Their unseen role in shaping rulings, like narrowing antitrust enforcement, reveals how young elites indirectly advance donor agendas within hallowed judicial chambers. Judges with ties to private prison donors, like Geo Group, have upheld harsh sentencing laws that fill cells. For-profit prisons lobby for policies like mandatory minimums, and compliant judges oblige. This symbiosis between courts and incarceration profiteers highlights how justice is commodified for billionaire gain. Countries like Norway prohibit judges from political donations or corporate side jobs, ensuring impartiality. In contrast, U.S. judges can invest in stocks, attend donor-funded retreats, and lobby post-retirement. This disparity underscores how America's lax ethics laws enable systemic corruption absent in robust democracies. Judges with tech stock portfolios often rule in favor of companies like Meta or Google in antitrust and privacy cases. The 2023 Gonzalez v. Google decision, avoiding Section 230 reform, benefited tech giants. Critics argue such rulings reflect financial conflicts, not legal merit. Despite overwhelming evidence, judges with pharma connections have delayed or diluted penalties in opioid cases. Purdue Pharma's bankruptcy deal, approved by a judge with undisclosed industry ties, shielded the Sacklers from liability. Victims' families decry these rulings as proof of justice skewed by money. Corporations file lawsuits in districts where judges like Matthew Kaczmarek, a Trump appointee with oil industry ties, routinely kill environmental regulations. Recent rulings blocking EPA emissions limits exemplify how strategic venue selection ensures billionaire-friendly outcomes. While pro bono work addresses systemic inequities, judges prioritizing corporate cases, like patent disputes, allocate disproportionate resources to wealthy litigants. This imbalance starves public interest litigation, entrenching a two-tiered system where money dictates access to justice. Billionaire-funded groups like the National Republican Redistricting Trust lobby judges to uphold gerrymandered maps. In Rucho v. Common Cause, 2019, the Supreme Court refused to curb partisan gerrymandering, empowering donors to buy political landscapes through compliant courts. Judges funded by evangelical groups often prioritize religious freedom in custody battles, favoring parents aligned with conservative values. These rulings, disproportionately affecting LGBTQ+ and non-religious families, reveal how donor ideology infiltrates personal legal matters. Federal judges frequently defer to Pentagon-linked corporations in cases involving defense contracts or surveillance. The dismissal of lawsuits against Boeing for faulty equipment, citing national security, illustrates how corporate influence masquerades as patriotism. Judges who receive campaign funds from insurance giants routinely uphold claim denials or weaken ACA provisions. A 2022 Texas ruling striking down HIV prevention coverage highlights how donor interests override public health. Judges reliant on police union endorsements often dismiss misconduct cases or reduce sentences for officers. This quid pro quo perpetuates systemic brutality, as seen in minimal consequences for killings like Breonna Taylor's. Corporate-funded legal journals publish skewed studies judges cite to justify rulings. For example, Exxon-funded climate research has been used to dismiss environmental suits, blurring lines between scholarship and lobbying. Life tenure insulates federal judges from accountability. Justices like Clarence Thomas, accepting luxury gifts for decades, face no repercussions. This permanence enables long-term donor influence, entrenching bias. Judges overseeing defamation cases involving outlets like Fox News often rule leniently, fearing backlash from powerful owners. Conversely, independent journalists face harsh penalties, exposing how media conglomerates manipulate courts to silence critics. Corporate-backed NGOs, like the Pacific Legal Foundation, file lawsuits to erode regulations. Judges sympathetic to their libertarian funders, such as the Kochs, use these cases to set broad precedents benefiting billionaires. Judges rubber-stamping deportations fuel demand for ICE detention centers, enriching firms like CoreCivic. With donors lobbying for stricter enforcement, rulings prioritize profit over human rights. While AI could analyze cases, algorithms trained on biased data or funded by tech giants may automate injustice. The lack of transparency in AI tools risks codifying corporate preferences as neutral law. The American judiciary stands at a critical juncture, where the scales of justice risk becoming mere instruments of wealth and privilege. From Supreme Court justices accepting undisclosed gifts to lower courts systematically favoring corporate interests, the system's veneer of impartiality has cracked. Yet, history shows that unchecked corruption eventually sparks reform. The path forward demands radical transparency, banning dark money in judicial elections, enforcing strict recusal rules, and dismantling the revolving door between courts and corporate boardrooms. Without these changes, the law will remain a weapon of the powerful, not a shield for the people. The choice is ours: tolerate a legal system auctioned to oligarchs, or fight for one that serves justice, blind, equal, and truly for all.